Hey guys, welcome back to the Legal Room podcast. This is our second episode. Today's topic is the coronavirus negligence, liability for COVID-19 transmission. This video will be highlighting key issues on being infected with COVID-19 at workplace, public places like shops, stores, and private places, and being able to sue those that expose this to you or who caused you to get infected with COVID-19 or coronavirus. Can people infected with COVID-19 sue the people who transmitted the disease to them for negligence, even if those people did not do so knowingly? This video will give you a clear answer in relation to this question. This question is likely to arise soon, as people may seek damages for losses resulting from socially irresponsible conduct. People get infected at work, in public places, and sometimes in private places. We all know that children are back to school now. Most employees are also getting back to work. People are going to shops and stores and so forth, which means that there is a high chances of getting infected with coronavirus. Getting infected at workplace. Employer's obligation. What does the South African law say about this? Employers have a legal duty to provide and maintain, so far as is reasonably practicable, a working environment that is safe and without risk to the health of his employees and anyone else who may be affected by the employer's business, including customers, suppliers, visitors, and members of the public. Employers are required to undertake risk assessments regarding the risk to the health and safety of employees and anyone else who may be affected by the employer's business. In doing so, employers must consider whether their existing arrangements for protecting employees and visitors take account of the risk arising from COVID-19. This would include identifying the likelihood of employees contracting COVID-19 while at work and appropriate measures to control that risk. An employer who does nothing could be said to be negligent and will be held liable. The Compensation for Occupational Injuries and Disease Act, known as COIDA, protects employers from liability where employees contract an illness at work or during the course and scope of their employment. Such employees ordinarily claim from the compensation fund without having to prove the employer's negligence. However, where an employer has been negligent, the employee may receive increased compensation, and the cost of same may be from the employer's account or pocket in the form of increased assessment rates. The Minister of Labour has held that employees who contract the virus while performing their duties will have to be compensated. The reality of this and by whom such employees will be compensated is not yet clear. An immediate difficulty is how does one prove that an employee contracted the coronavirus during the course and scope of their employment? We assume that such compensation will have to be paid from COIDA, and COIDA only applies to employees. Customers, suppliers, etc. will have to institute a civil claim against the employer if they seek to recover damages against them for negligence, and a usual delictual principles will have to be put in place or will apply. Getting infected in a store. If you get infected with COVID-19 in a store or a shop, you may have a claim against the shop or store owner if you can be able to prove that the owner did not do enough to protect its customers from this disease. Among other concerns, this can be due to the owner having not done enough to enforce social distancing guidelines, or to properly sanitize the store, or prove sufficient personal protective equipment for employees, or maybe to provide these equipments. Employees who work in a store or shops can also sue their employers should they get infected at work, provided that the shop owner failed to take reasonable steps to prevent the spread of the infection. Sometimes it can be because employees were not given opportunities to wash their hands, not being provided with sanitizers, protective masks, or fully adhering to the coronavirus guidelines. Sometimes it can be that the employer had not implemented a plan for testing the contact tracing workers exposed to the coronavirus. In order for a coronavirus victim to be successful in a claim, or typically in order to establish a cause of action for negligent conduct, there are 4 criteria that need to be met or proved. A person bringing a claim, who is known as the plaintiff, must establish that the person being sued, who is known as the defendant, owed or owes him a duty. That's the first criteria. The second one being that there was a breach of that duty. The third one being that there is a causal connection between the defendant's conduct and the harm incurred by the plaintiff. The last one being the damages. So in detail, I will touch into these criteria. The first one being a duty to prevent the transmission. So this is the first criteria that need to be proved or to be met. And we all have a duty to prevent the transmission, and there is a public policy to prevent its spread, like the lockdown regulations and the World Health Organization guidelines. We owe a duty to other individuals, particularly to those in close proximity with us. The second one being a breach of duty. After establishing that there was an existence of a duty, we must show that the duty was breached. A breach of the duty to prevent the transmission of disease, and in this case COVID-19, occurs when a person who tested positive for COVID-19 or a person who has had symptoms of COVID-19 leaves his or her house and visits public areas or uses public services. Due to the ease with which this spreads, it is highly likely that the infected person will transmit it to the other individuals. Therefore, if the infected person leaves the house knowing or suspecting that she or he is infected with COVID-19, then he or she breached the duty to prevent the transmission. The third one being the causal connection. After establishing that the duty was breached, there is a need to demonstrate that the breach was the proximate cause of the plaintiff's harm. And this can be due to how ease with which COVID-19 spreads. The presence of the infected person in public places puts others at an unreasonable risk of contracting it. The last one being the damages. The final element to be proved as it is, this includes the cost relating to medical expenses, physical pain and suffering, which ultimately may lead to death. So where it leads to death, the people who are bringing claim or the dependents of the person who died may be able to claim what is known as loss of support. So the loss of support is a result of losing a person who supported or provided for them. To conclude, it is the responsibility of every person to act in a responsible way when he or she knows or should know that he or she is infected or may be infected with COVID-19. When individuals negligently transmit the virus by leaving their house and visiting public areas, they should be held liable. This marks the end of our second episode, and watch out for our third episode coming soon. Stay safe and warm. Thank you for watching. Bye.